Welcome, everybody. This is The Lawyer Show. I'm your lawyer, Jeremy Rosenthal. The Lawyer Show is a weekly podcast. We are on between noon and 1 on Thursdays, and we try to do it on Facebook Live. We try to reach as many people as are interested, all 2, 3, 4, 5 of them. This has been a very exciting diversion for me during the pandemic when we could not try cases, when I couldn't necessarily be in court. And I have, now that courts are coming back and we're getting to go to court, I have people who come up to me in the courthouse and they say, "Man, Jeremy, I've seen your podcast thing." And I'm like, "Really? What did you think?" And they say, "Well, I didn't really see it. I saw that you had one and I considered clicking on it and watching it," which tells me that that's, I think they're being honest there. I think if they told me they watched it, I take it to mean maybe 3 minutes or less of it, but that's fine. You know, we're here to entertain. We're here to just kind of shake things out. This is the idea is that this is just kind of lawyers talking, water cooler talk, what you hear, how we are, all that good stuff. My guest today is somebody he's just really fascinating for a lot of reasons, as are frankly all of the people who I invite on the show. And he is a guy who, I don't know how to say this or how to explain it. He does live in Houston. I'm not sure if he's the first Houston lawyer we've had on the podcast. I want to say, because there's a lot on this show. We make a lot of jokes about Baylor lawyers. We make a lot of jokes about Tarrant County. We ought to make a lot of jokes about Houston for reasons that we'll get into here very shortly. My guest today he's attorney Jorge Barunda, and he's a lawyer from Houston. He is the quote unquote equalizer, which, man, I love that. I saw that on your website, and he is the equalizer. As everybody who's watching already knows and appreciates, mentally I'm kind of a giant. You know, strategically I think 3, 4, 5, sometimes 10 steps ahead of my opponents. Jorge, you should know, is beating me 71 games to 50 games on Words with Friends. So Jorge can not only think more quickly than me, more strategically than I can. He also knows probably every time I'm indisposed. With that introduction, ladies and gentlemen of the jury, my co-counsel today, Jorge Barunda. Jorge, talk about yourself briefly. Tell us who you are, and let's talk first about, well, I told you we would lead off with products liability, but first introduce yourself to JP, Kathy, and the Crew Nation.
Well, good afternoon, everyone. My name, as Jeremy said, is Jorge Barunda. I am a lawyer here in Houston, Texas. I am happily married to my wife, Jennifer. We have 2 8-year-old children, a boy and a girl, Sophia and Mateo, and a wonderful, once again, teenager by the name of Alexis. Happy to join Jeremy. I've known him for a very long time, and just kind of excited to see where this goes today.
This is going to be great, man. And so everybody knows lawyers are parents too, right? And we were just talking just before we began, and I noticed that you said that your 17-year-old was once again. Is she going to listen to this, by the way?
I like to give her a hard time. I think she recognizes that she went through some growing pains.
Growing pains.
And so I like to point those out sometimes in retrospect, and we have a laugh about them. So I may actually make her watch part of this.
Yeah, I was telling you I've got a 10-year-old, and you told me that the warning years, at least for y'all, were between 11 and 15. That was when things were difficult?
Yeah, once you know, certain hormones start surging, I guess, I don't know, once they start getting into a particular age range, they suddenly forget how much they like you or love you, and they believe they know everything and want to go out and experience everything, no matter the consequence.
Yeah, so you didn't know what to expect at all coming on here. I baited you. I tricked you on here thinking that we were going to talk about, exciting things in your practice. So far, we've talked about when I'm indisposed, number one, and number two, female teenage hormones. But let's get to products liability. Again, not that those other things aren't interesting, and not that we couldn't talk about them for a while. You're the first products liability lawyer that I've visited with. So tell the jury what products liability is.
Sure. So products liability is a field of practice where manufacturers and sometimes sellers of any given kind of product are exposed to liability because of something that was done incorrectly in the way the product was conceived, designed, manufactured, or marketed. And as a result, that product gets out into the world, whether that product is a tire or a vehicle or a pharmaceutical product. It gets out into the world and it causes harm to somebody that was avoidable.
So I would think a lot of manufacturers and I think that when you're talking about a tire, for instance, there's a lot of manufacturers who touch that thing before it hits the road, right? So how do they sort out who's at fault and if something malfunctioned?
There's a through the discovery process, there's a large screening process. You have to explain all your different theories, and as it depends on which side you're on, but nowadays I find myself most often on the plaintiff's side. You really have to drill down and explain what it is about that particular product that caused the injury, right? So, for instance, let's talk about the tires.
Okay.
For instance, a tire can cause an injury because there's a blowout or a tread separation. And as a lawyer, you have to find out if it was the way it was installed on the vehicle, if there was something wrong with the materials in the tire, if there was something wrong in the manufacturing process of the tire, or if there's something wrong in the way that it was marketed. Say the particular tire is marketed for off-road use and it's not actually suitable for off-road use, and something goes wrong while you're using it off-road and you get hurt. So it's my job on the plaintiff side to explain to the judge and ultimately the jury, this is what was wrong with the tire. This is the party responsible, whether it's a supplier, a manufacturer, the marketer of the tire, or the entity that brought the product to you and told you how to use it.
So how does the liability work? I mean, because obviously these people are going to point the finger at one another, and to be fair, I mean, your plaintiff, if let's say, for example, a car, there's a blowout, the car flips over, somebody is hopefully not too injured, but oftentimes can be either killed, could be a paraplegic or something like that. How does the liability work on it? Because when you're coming to the jury or when the case starts out, when they come into your office, all you know is that you've got a guy in a wheelchair, for instance.
Sure. And so the first thing you investigate the facts of the case, what happened, and you try to identify the greatest number of potential defendants. You see out of that pool of defendants which are the ones that actually touched on the part of this product that ended up causing the injury. And then you oftentimes, if you have a solid, reasonable basis for doing so, you name them various defendants, and through the litigation process, whether it be through discovery, through motions to dismiss, motions for summary judgment, certain other mechanisms, you end up narrowing down to the list of the most likely responsible party or parties, and you go from there.
That sounds like a pretty expensive proposition for a plaintiff. What are some examples that you have, and what are some of the challenges that in particular to a plaintiff as far as prosecuting the litigation, financing the litigation? What are some of the challenges that you run into?
Well, first and foremost, you've got to recognize that when you're talking about product liability, you're most often going to be suing a very large corporate entity. And as a very large corporate entity, they have a lot of money to fight you. They hire very good, very large law firms. I started out at a very good, very large law firm representing General Motors. So they can spend hundreds of thousands, if not millions of dollars, defending a particular case, depending on the merits of the case. And that brings a lot of pressure to bear on the plaintiff and his counsel. They have to really know what they're doing and be prepared for what they're about to undertake. Then you go from that to the hard costs of things, right? So, for instance, let's say we're talking about a commercial truck rollover. These happen a lot. And one of the most common things you see in an incident like that is that the roof of the truck cab caves in and ends up crushing the occupant or rendering them paraplegic, quadriplegic, whatever. And in products liability, you're going to have multiple expert witnesses, right? You're going to have engineers that can talk about what was wrong with the design of the vehicle, what could have been done differently, whether it was economically feasible to do it in the product without rendering it out of reach for most consumers. So you have a lot of costs in that regard. In some of the cases we handle, sometimes we actually have to go buy the truck or a similar truck and drop it on its head so we can demonstrate the similar incident to the jury. And then we first do it we put a cage in there and then we drop it on its head. It survives fine. Then we take the cage out, which the manufacturers often don't put in it, drop it on its head. It pancakes. And from that point on, it's very self-explanatory. But it's a very cost-intensive process. On top of that, you also need, oftentimes, medical experts who can talk about why it is that the particular defect in the product led to a particular injury and what your future looks like as a person, whether you're going to need ongoing medical care in the future, whether it gets very convoluted. You can also hire economists in the case of lost earning capacity to explain what your lifetime earnings were going to be in all probability, what they're going to be now. That's another element of damages. At the end of the day, you're talking about retaining experts in various fields, and experts rightfully charge a decent amount for their time because they're very well trained and knowledgeable, but it's a costly proposition.
You're watching JP, Kathy, and the Crew Network. You can see JP, Kathy, and the Crew between 7:30 and 9 on Monday, Wednesday, Friday. This is The Lawyer Show. We're on between noon and 1 on Thursdays. I'm going to twist off just for a second here, Jorge, because I want everybody to kind of just sort of break down what you just heard from Jorge about this, because number one, recreating an accident like the trucks that you were talking about and doing it twice, right? One with the cage inside, one without the cage. That is extraordinarily expensive. Has to be, right? I mean, I don't even know what the price tag is, but you have to do those types of things to demonstrate the liability, right?
Right, and it's also it serves two goals. The first is it demonstrates the alternative feasible design in the case of a truck rollover. You put a roll cage in the cab, it's going to save lives. It's going to avoid injuries. So you demonstrate the alternative feasible design, and then you show what happens when it's not present.
But
so that's point number one.
Yeah, go ahead. No, you.
The other thing, it's from an advocacy perspective. We prepare every case as though it's going to go to trial, even though the overwhelming majority do not. But you always prepare for this might be the one that does go, and you've got to be prepared to make a convincing presentation. And when you show a jury panel, or you show them, or not a panel, a jury, when you show the jury what can happen and how it can be avoided, it's a very impactful thing.
And you're also selling the defendants too. You're also saying this is what the jury's going to see, and if you're going to sit there and convince yourself you're not at fault, let me show you this. But I think the bigger point here too is that we hear a lot of complaints about tort reform. We hear a lot of complaints about, well, not complaints about tort reform. We hear a lot of complaints that say, well, we need to get rid of the lawsuits, get rid of the lawsuits, get rid of the lawsuits. I think people need to understand the reason why America, right, the U.S. of A., why things are so safe here, why baby products, for instance, are so safe here, is because of people like you, people who spend their own money to drop trucks on their head twice to make sure that defendants, that manufacturers do it right. Because they're not going to do it. They're not going to make these things properly out of the goodness of their heart. They're going to do it because they don't want to get sued. Am I crazy?
No. I mean, at the end of the day, corporate entities, in my experience, are purely economically driven, and so they're going to do whatever maximizes their profit, right? And there's two ways to approach that for them. They can minimize the cost of a particular product, thereby boosting their profit margin. But if they do that too much, then on the other side of that is the potential for liability. And so there's a friction there. And as a plaintiff's attorney, as a person who represents people who are injured, one of the things that is my job to do is to make it costly for a corporate entity to ignore a person's safety for the sake of profit.
Right.
Right. So you mentioned some examples. The classic example is the Ford Pinto, which I think was in the 60s or 70s. And that was a vehicle that if it was hit in a particular way in the rear, it would catch fire and explode almost a very high percentage of the time. Ford knew this, and they started having incidents all over the country, and they started getting sued. And what actually happened in that case is that they hired the bean counters, quote unquote, to go out and tabulate what percentage of the cars would catch fire, how many people would be injured, how many lawsuits would be filed, settled, the cost of a judgment, etc. And then they compared that to the cost of going out there and fixing the small piece on the car that was causing it. And they decided that it would be costlier to fix the vehicles. And so they just rolled with it, and more people died. And eventually, thanks to some enterprising plaintiffs' lawyers, this came to light. A jury didn't take very kindly to that, and they slapped Ford with what's called exemplary or punitive damages. Those are damages to punish bad conduct and to prevent or disincentivize future bad conduct. And it was a very large amount that they hit Ford with, and Ford changed its practice. That has happened in almost every field of commerce that you can think of over the course of time. And it is in large part because of that products have gotten safer and safer and safer over time.
Right. And so let's say, for argument's sake, something I read, I don't know how long ago it was, suggested that one of the most popular American products that is sold overseas, and I referenced it a minute ago, are baby products, baby safety products, cribs, cradles, car seats, things like that. Now, when you're talking about the Ford Pinto, how many consumers are not going to buy the Pinto because of the 0.001% chance that the thing blows up when you're rear-ended, right? Now, I mean, now when you multiply that times however many hundreds of thousands of Ford Pintos were sold, those are 10, 15, 20 real humans that died, maybe 100. I don't know. But one place where people are not going to skimp, and one place that it actually sort of aligns the market practices, are in baby products, because again, who's not going to spend as much money as they can to make sure that their child is as safe as they can be, right?
Sure.
Yeah.
Car seats.
Oh, go ahead.
Beds. No, I'm just agreeing with what you're saying. Yeah, I mean, you'll go to the store, you'll have a budget in mind, and then a salesperson will come out and tell you, this one's good, this one's better, and you'll go with the better one every time because you want the best, safest thing for your child.
Right. And some stores will come out and they'll say things like, this is better, this is the best, and this one is exceptional. That's an inside joke here. My office manager is Heidi. She's sitting here. Is that that was the, I can't talk about this, can I? The Container Store? The foundation principle. That's how they used to sell people. I don't know how much products lie. Maybe some. Maybe there are some liability issues with containers. There probably are. Anyway, it always fascinates me how people think of these things too, because they also think that, well, let's say the U.S. makes a law that regulates whatever, right? Tire tread. These things don't enforce themselves. It's you that uses that regulation to prove up a negligence case, right?
And I'm sorry, you're cutting out on me, Jeremy. I can see you, but I can very faintly hear you.
Oh, it didn't really make sense anyway. It was a great point that I just made. Brilliant, in fact. In court, what I would do is I would have the court reporter read back the record. So the viewers are actually going to just have to go back and rewind that just to hear how great it was, because I'm not going to say the same thing again. I think the point I was making was that you have to use – so when the federal government or the state of Texas puts a regulation in place as to a specific product, there's no real federal enforcement mechanism there. Am I right about that?
It depends on the particular product. For some there are, but by and large, when there is a law of general applicability to a wide number of manufacturers in a kind of a generic category, then yes, the law is out there. Compliance is kind of an honor system idea, and it really is up to, I think the concept, the way they talked about it in law school, was like the private attorney general, meaning individuals to go out there, and if something is done incorrectly, if a law is ignored, a regulation is ignored, and hurt somebody, it's up to you to defend your rights.
Mm-hmm. And kind of moving from there, so let's say we'll just take a big whatever, a big company, and it doesn't matter. Let's say that they do violate something. What the law provides for you is that you as a plaintiff's lawyer can use that in your pleadings as part of a negligence action that says this is negligence per se. In other words, you guys violated this statute. Therefore, that is proof that you're negligent. That's how some of these laws and regulations get pushed. Am I right?
Correct.
Okay. And so in essence, what we're doing too is, and I've told folks too who argue against, who argue for tort reform, right? We're going to get rid of all the frivolous lawsuits, right? In quotes. The point that I make is, look, you can either have really high taxes to enforce these things, or you can let plaintiffs do it on their own dime, right? And we don't, and people just, when people argue for tort reform, they're saying, well, we just don't want either, right? But that's how you get Ford Pintos that blow up. Yeah?
Correct. Right. No, so look, large corporations have vast sums of money and lobbyists and lawyers, and they can make campaign contributions that sort of bend the system for their benefit. And they have marketers that go out there and establish things like, I'll make up some name, Neighborhood Watch for Tort Reform.
Right.
Which actually ultimately funded by
an insurance company,
the U.S. Chamber of Commerce. Right? And it's there to push the idea that lawsuits are out of control. We need reform. They're costing you more money. And so they convince individuals of this notion that indeed lawsuits are out of control. And they get people to, in essence, cheer against protections for themselves.
Right.
Thankfully, most people have limited contact with the legal system. Most people don't end up being in a lawsuit, don't get hurt by a product. They just hear about it in the media. And so it's easy to convince those people that lawsuits are frivolous and that they need to be restricted. But when somebody's hurt, even if that somebody is somebody who was previously ardently for tort reform,
Right.
the light bulb comes on, and they realize, oh my goodness, I need a legal system that will protect me as well.
Man, I see the same thing as you might imagine in criminal cases. Everybody is for safety. Everybody is for law enforcement. Everybody is for hard-on crime prosecutors until it's your nephew, until it's your daughter, until it's your niece, until it's your spouse, in which case, well, where are my constitutional rights? And then I say, well, we're about to meet a panel of 60 potential jurors, 80 potential jurors, all of which are going to really cheer for the police,
And
right?
You cut out again. I'm sorry. I heard the last bit of it.
Man, this thing is we have very smart equipment here. When I make such an awesome point that it's overpowering, it just the equipment just goes off. Let's talk about commercial litigation, and let's talk about your commercial litigation practice, because that's another area where you're duking it out with some probably big, tall building lawyers. Talk about what is commercial litigation and what your role typically is in it.
Sure. So commercial litigation it's actually a pretty wide field of practice. In essence, it boils down to business disputes. And that could be a dispute between two mega corporations, a large corporate entity, and an individual or a small business, or two small business owners. They make some kind of they get entangled somehow in business relations. Whether they're making a transaction together, or they agree to build an apartment complex, or whether they're competitors and one of them is doing something a little bit underhanded to gain an advantage. A dispute breaks out, and it's a fight. That's where we come in, and you end up representing either somebody who is being sued for breaching a contract, for misappropriating intellectual property, for breach of warranty, that kind of thing. Or you end up representing somebody who needs an attorney to go out and recover for them because somebody on the other side either didn't live up to their end of the bargain, or they did something that you could characterize as unfair competition and harmed their business. And it's a pretty neat field because it sounds really sterile when you talk about it in those terms. But at the end of the day, the overwhelming majority of businesses in the United States are small to mid-size, and you're talking about people and their livelihoods. And at the end of the day, you can see how these commercial disputes impact people's lives, the employees, the families, everybody. And so it's really neat. It's very complex. And at the same time, there's a large human element to it.
You're watching JP, Kathy, and the Crew Network. You can see JP, Kathy, and the Crew between 7:30 and 9 on Monday, Wednesday, and Friday. This is The Lawyer Show. We are on between noon and 1 on Thursdays. I am your lawyer, Jeremy Rosenthal. My co-counsel today is Houston attorney Jorge Barunda. Yeah, so I have, in a prior life, I don't think I've touched a civil case probably in over 10, 12 years. That was one of the things when you get involved with like business divorces. I mean, there's two edges to it, right? One is that it's just really, it can be very bare knuckles, number one. And then number two, there are real consequences for these people because they're all shelling out a lot of money, and not all of that. Some companies may have they may have some resources, but not unlimited as big corporations may. Is that what you find?
Absolutely. Litigation is, by its nature, very expensive. And attorneys generally bill one of three ways, sometimes hybrid, but they either bill by the hour. And for instance, my hourly rate is $450 an hour. That adds up quick. They bill on a contingency where they recover a percentage of whatever thing of value they recover for the clients, or they bill on a flat fee, where they just sort of come up with a number based on the type of dispute, and they collect that up front, and then they're on board for the duration. But in commercial litigation, you rarely see the flat fee, so you're talking about hourly or contingency. When you're talking about an hourly rate, a deposition takes, let's say, a 6-hour deposition of an important witness. It'll take you 8 to 12 hours to prepare for it, and then your 6 hours to conduct it. Imagine that at the rate of $450 an hour, and that is a moment in time in the course of a piece of litigation. Mm-hmm. The money adds up very quickly. So, frankly, a lot of times, good legal representation is out of reach for a lot of folks. Mm-hmm. And that is why I think, and frankly, I prefer the contingency fee arrangement myself, mm-hmm. because it's one of the few things that actually aligns the lawyer and the client's interest perfectly, mm-hmm. right? In a contingency fee case, I recover a percentage of whatever it is I recover for my client. So my interest is in maximizing that recovery and getting it as efficiently as possible. In an hourly case,
but you have to make sure, but you have to make sure that the money's there on the other side, right? And most small businesses don't make particularly good targets for collection in Texas.
Right. That's one of the misconceptions about the civil judicial system, mm-hmm. and that is that if you go to trial and get your judgment, you're golden.
Right.
But you're not. You get a piece of paper that says you're entitled to collect from that guy over there X amount of money. Good luck to you.
Right.
And that's a whole other headache is collecting. You've got to, when you're dealing with large corporations, it's not a problem. Mm-hmm. When you're dealing with business entities that have a general commercial liability insurance policy, that helps. But when you're talking about two small businesses, it's very difficult to actually, at the end of the day, collect the entirety of a judgment. Mm-hmm. That's why oftentimes what you'll see on the civil side of things is lawsuits are resolved through negotiation and agreed settlement. Mm-hmm. Because then you're going to get something.
Right. One of the things, too, that I think most people don't, at least when I was doing civil stuff and civil litigation, what folks didn't understand, they say, well, why don't these two people just, instead of slugging it out, let's just go hug it out, right? Let's just go and settle the case. And what I found, you tell me what you think, what I found that was challenging about that is you got to punch the other guy in the nose first, because everybody comes to the table. I didn't handle very much family law at all. And I want to say that maybe my first or second or third year out of law school, I had a divorce that came into the firm I was working at, and the husband and wife come together. We're agreed on everything. They say, oh, great. Well, this will be easy. Okay, so now understand, and I give them a lecture of once we start disagreeing, I can't do this anymore. I can't represent y'all. It's going to be a conflict. And so we go through a handful of things. Okay, and I don't think they had kids. We're agreed that you're going to get the lawnmower. We agreed that you're going to get the car. Okay, now what are we going to do with this house? Well, that's where we disagree. And so, just the house, right? Just the only asset between you guys. That's okay. So it sounds like we're actually not agreed here. And then guess what? It turns into a divorce, right? So, and it turns into a real divorce. But that's what folks, I'm sure when they come into your office, I'm sure that they come in with the story of, I am the victim, they are wrong, I am right, there is no question about it. All we have to do is just make a demand, and they're just going to pay it, and this is going to be done. Does it work like that?
Well, so yes, a lot of people come into my office with that idea. Let me first say that nobody ever goes to a lawyer first when there's a disagreement, mm-hmm. right? Yeah. People, that's not human nature. There may be some that do, but in my experience, nobody has. Mm-hmm. I'm kind of the last guy they come to see when there's kind of a problem like this.
After they've already admitted things that they probably didn't need to admit?
Yeah, after they've laid some landmines out there in the litigation for me to discover later on. But yeah, very often when I tell people I'm happy to do it on an hourly rate, got an hourly rate. I'm going to charge this as my fee and my hourly rate, and I need this kind of a retainer as a security deposit. Their eyes kind of go wide. Oh my goodness. And then they say, well, what's the other possibility contingency? And oftentimes what happens is they say, well, look, I know that we get the demand letter out there, they're going to get scared, or they're going to come to their senses, or something's going to happen, and we're going to be able to resolve this lickety split. That I've been doing this for 21 years now, which is sad to say, but that's happened one time. I'll send out my nasty gram, and if I get a response, it's usually a very nicely worded middle finger. So then we get into the nuts and bolts of it. But I've had people that will hire me on an hourly basis, thinking that it's going to be done quickly, and once they're a few months in and the bills are starting to pile up, they come back and say, hey, look, can we rethink our business relationship? Can we do some sort of contingency now, or what have you?
Yeah.
But in my experience, once you go to a lawyer, it's because the dispute has gotten to a point where it is not going to be resolved without some wrestling around in litigation.
There just has to be bloodletting. I mean, I hate saying it like that, but in most instances, there's got to be a little bit of bloodletting. There's got to be a little bit of it's the pain that brings people to the bargaining table, right?
Absolutely.
Yeah.
Everybody has to see that everybody has to be properly motivated to come to the table to resolve the thing. Otherwise, everybody's convinced of their righteousness and nobody's willing to budge.
I'll tell you a funny story. I actually got a certification. It's probably been about 10 years ago, 15 years ago. I actually got a certification as a mediator. I followed around a mediator for 2 or 3 mediations. And what I found, and so for the audience, what mediation is, if you don't already know, we don't really do it in criminal cases. We may consider that. But what mediation is you basically both parties go, or however many parties are in a case, they all go to a neutral person who tends to be kind of a sage type personality, and a former judge or another type of wise individual, right? And basically what happens is the mediator goes from room to room to room, convincing everybody they're going to lose, and being honest about it the whole time. And what I saw, Jorge, was that the most unreasonable lawyers generally got their way, unfortunately, which was you would go in one room, there would be somebody sitting there crying and talking about how they just want this to end, and a lot of times that person would legally be in the right. But they want the thing to end. They want the thing to go away. They're done paying their lawyer. They're done not sleeping at night and all that stuff. And you walk into the other room, and there's a self-righteous, self-assured asshole lawyer with his client there. This is sort of it's a quasi-family friendly network. We've already talked about my restroom habits here today. We can't get much lower than this, can we? But you walk into the other room, and there's just this real asshole lawyer in there with his client, just so convinced that they're right. Well, footnote 39 says this. Typically, what I saw in the mediation would be that the weaker personality would cave. What are your thoughts?
So the first thing that comes to mind when you say that is that litigation is tough. I mean, it is not easy. And this is something that I tell my clients when they come to me is, listen, I'll be your champion. I'll go out there and I'll engage in the fight, but you've got to stick with me, because it keeps people awake at night, especially when it's litigation of consequence. When you're talking about a bet the family business lawsuit, or you're talking about somebody who's injured and the hospital bills are mounting up and they don't know how they're going to get by, or when you're talking about mom and dad passed away, and the wicked, conniving stepbrother is trying to steal the inheritance. It keeps people awake at night. It's emotionally difficult. When people go and sit in the deposition chair, the chair when they're being interrogated by the other lawyer, it's a stressful situation. And so, yeah, a lot of times you'll have folks get this, whatever it takes, just get it done scenario. And yeah, in mediation, you'll have situations where the other side becomes unreasonable, and if you're not careful, that can lead to bad consequences for your client, right?
Yeah.
And I remember in law school, we had this, one of my professors, I can't remember who anymore, was pushing this book called Getting to Yes.
Yes, I've read. No, they made me read that.
Yeah, they made me read it too. It sounded lovely. It doesn't work because it takes two people that are willing to work collaboratively to get to yes. Otherwise, if one party's going yes and the other one's backing away, they just pull you to their side.
Yeah.
So, and then the last thing that happens at mediation is that people get, I call it deal fever. We're at mediation, we have to settle.
Yeah.
And you don't. That's the thing about mediation. If you don't get something that's fair and reasonable, you can stand up and walk out.
Right.
And number one, I tell clients, it's not your last opportunity to resolve this thing through negotiation. The negotiations can continue. We just need to do something in litigation to persuade them more that they need to settle. And ultimately, if it requires it, we'll go to trial. And there's your the jury more often than not gets it, much more often than not gets it right.
So here's a question that I have for you. I've got an answer in the can that I get asked this quite a bit in criminal cases. And I'm sure you do too. I get the question, what if it was you? What would you do if this, what decision would you make if it was you? If it was your son, if it was your daughter, if this was you on trial? I'll tell you my answer in a can. Then I'm guessing you have a very similar speech because I don't know a lawyer yet who has not been asked this a million times. My answer is that I am not you. I don't know what keeps you awake at night. I don't know your tolerance for pain. I don't know your threshold, okay? I don't know what's going to bug you in 10 years. I don't know if you're going to hate yourself in the year 2042 because you went and took a deal here. I'm not you. I want to go and win your case. That's what I want to do. But again, that's kind of my answer in a can because we get asked that a lot. Do you get asked that a lot?
Oh, yeah. And it's similar to yours, but mine's a little bit more nebulous.
Okay. Let's compare notes here.
I start by saying, look, I'm a lawyer. This is what I do. I enjoy what I do. And if I'm talking to the person at this point, it's because I think there's merit in the case and I want to represent them. So I'll tell them, I want your case. I want to represent you. But as far as what you should do, what I would do if I were you, I would look at my circumstances. I would look at how this will impact me financially, how it will impact my family, how it will take me away from things that are important to me, whether that be my business or my hobbies or whatever the case may be. I will look at what other things I can do to improve the area that this harm has harmed. And then based on those things, depending on what the answers are, you weigh those and you decide whether you want to go forward or not. But if you do go forward, you've got to be all in.
Right.
Because litigation is tough. And it's kind of a screening thing for me.
Yeah.
That's why I tell folks this. If you go forward, you've got to be all in because litigation is tough. And you're either going to pay me hourly or you're going to pay me on a contingency, but there's going to be a lot of investment that's going to be made by one or the other of us. And if at some point you get tired and you just want to give up the ghost because you're tired, it can hurt us both. So you've got to be in all the way if you go in.
Yeah, I like that answer. I like that answer a lot. I'm probably going to steal from it. I'm not going to give you credit. That's how I am. You're watching JP, Kathy, and the Crew Network. You can see JP, Kathy, and the Crew between 7:30 and 9, Monday, Wednesday, Friday. This is the Lawyer Show. We're on between noon and 1 on Thursdays. I am your lawyer, Jeremy Rosenthal. My co-counsel today is attorney Jorge Barunda. Let's talk about your story, Jorge. I've known you since 1989. I'm an 890 from New Mexico Military Institute. You're an 880, right?
That's right.
Okay, so and I know a lot of your story. They don't. The jury doesn't. But I also want to know how your practice evolved into where it is, because you've got you have it broken down very interestingly, because you do products, you do commercial litigation, and we're also going to talk here, if we get time, about inheritance disputes, and I want to get into that. But so tell the jury what your story is and how your practice came to be the way it is.
Sure. I'll run through it really quickly. So
in 45 seconds. No, I'm kidding. Take your time.
So my family is from Mexico, and we had a large cattle ranch in Mexico, and we had some unsavory neighbors that really had a negative impact on my family, and the criminal justice system over there wouldn't do anything about it. And so once I was in school over at UT Austin, I really got into the idea of being a prosecutor. I wanted to be a prosecutor in the United States. I saw the justice system over here as a shining beacon. And so I wanted to be a prosecutor, and when I got into law school, I wanted to be a prosecutor, and then some prosecutors came and told us how much money they made. And that was a tough pill to swallow, right? At the same time, I was being recruited by some firms that were offering a nice bit of money. Mm-hmm. And so I ended up going to one of the biggest that paid me very handsomely. And while I was there, I started out doing products liability defense, representing General Motors, Bombardier, U.S. contractors, a lot of different manufacturers in very large disputes. Didn't really make me feel great. I'm more inclined to represent individuals over mega corporations. It's just my philosophical makeup. And then I switched from that in the same firm to commercial litigation, and we represented companies like Enron when they created buckets here in Houston. And that also didn't feel fantastic, but it kept the lights on.
They have rights. They have rights, and they maybe in certain ways, I'm sure they were very misunderstood. It's okay.
Sure. So anyway, I ventured out from there, joined forces, but went to more smaller boutique litigation firms, did a variety of things, still in the products liability, commercial litigation, personal injury types of stuff on defense and plaintiff side. Over time, I ended up striking out on my own, partnering up with some folks, and that's when I came to realize I really like representing individuals or small businesses that I feel haven't been given a fair shake. Mm-hmm. That's what gets me up in the morning and gets me out the door and really drives me. Mm-hmm. And I've done that. I'm happy to have been able to do that in personal injury, products liability type cases, in commercial litigation type cases. And now, one of the things that a friend of mine a few years ago got me interested in, and it's become an increasingly bigger part of my practice, is this idea of inheritance disputes. Mm-hmm. And it brings together a lot of these elements that I've talked about before: the very interesting, complex part of commercial litigation, mm-hmm. the very human aspect of things like products liability and sometimes commercial litigation. But it brings it all together. And you think about, where do inheritance disputes come from? Well, somebody with some assets passes away, and there is a disagreement afterwards over how it should be distributed among that person's heirs or whoever that person wanted to leave things to. And just think about the idea. You have a man or a woman work their whole lives mm-hmm. to build something that they want to then pass on to, whether it's their children, their grandchildren, nephews, a charity, whatever the case may be. uh, there is they have no way of knowing if after they're gone it's actually going to happen. And the sad reality is that a lot of times the cliche plays out. The wicked stepmother comes in and gets the will changed, or suddenly the will disappears.
Good trial theme, by the way. Have you used that one yet? Have you been like, that's a good one.
I'm sorry, what was that?
Have you used that in trial yet? That's a good one. I like that. Wicked stepmother. That's a really good, that's good. I always, I think of trial advocacy. So keep going.
All right. So you end up with, I'll give you some examples. I've had cases where a man who's on in his years marries a younger woman, and the younger woman over time isolates the man from his children, keeps them away, and once father is weakened because of age or because of a particular medical condition, a new will is executed, leaving everything to the younger woman and her kids and excluding the biological children. Mm-hmm. That creates a lot of emotional harm for the children of that man. They when that man passes away, they're sad for the time that was robbed from them spending with their father. Mm-hmm. And then when the will comes to light, they're sometimes convinced maybe dad didn't love me. Maybe he didn't want to see me. And they come and they talk to me eventually.
Do you do plaintiffs and defense on those, or is it just typically, or are those contingency situations? Obviously, when you're the plaintiff, or are they?
They most often are contingency on the plaintiff side, because if you're talking about people who've been frozen out, they don't have the resources. If it's an estate of any magnitude, the person representing the estate, the will, defending the will, they have the resources of the estate to fight. Mm-hmm. The person who's been frozen out can't afford to fund the litigation. So oftentimes it is a contingency fee scenario. And it's my job when I'm on the plaintiff side, which I most often am. Mm-hmm. I do defense, but not as often as plaintiff.
Right.
It's my job to ferret out exactly what it is that led to this change in a trust, or this will being rewritten, or what happened to the will. What happened to dad had $10 million before he died, and suddenly we're saying that the estate inventory says that dad has $500,000. Where did it all go? Mm-hmm. So there's a lot of sleuth work that goes into it. And through the process, one of the cool things is that my clients on the plaintiff side very often end up with some catharsis. They come to realize that dad didn't mean to keep me away. Dad didn't mean to cut me out. This wasn't what he wanted. Mm-hmm. He did love me. That kind of thing.
So, but you don't get paid necessarily with catharsis. That's kind of one of those situations where the client comes to you and says, well, I feel better about this, Jorge, and you're kind of knee deep in it at that point. Does that ever happen?
And we have one of those little technical glitches again, where I heard you say you don't get paid in catharsis, and the client says they feel really great, but I didn't catch the rest of it.
Well, again, our system is very smart here. I have decided that when I don't make a very good point at all, it just cuts it off. So, but what I was saying was that you don't get paid with catharsis. No. So it's a great byproduct to have in a case like this. Sure. Talk about what it's like to defend the wicked stepmother. That's what I do a lot of, right? I go in front of a jury, and what I kind of think is that anybody can go to the 50-yard line of Cowboys Stadium in Arlington, or Texans Stadium in Houston, if you will, and yell, "Go Cowboys," right? That takes a little bit of courage. Okay, you got to overcome your fear of being in front of people. You got to maybe overcome a fear of speaking, but you're not going to get things thrown at you, right? You're not going to get batteries if you were like, I think that's the Eagles fans that do that. but you're not going to get things thrown at you. It takes a lot more courage to walk to the 50-yard line and say, "Go Giants," or to say, "Go Eagles," or another team like that. What's it like to represent the wicked stepmother? Have you been in that position, and what talk about how different that hat may be to wear?
It's very different. I've done it on occasion. Here's the thing: when the wicked stepmother comes to you, she doesn't say, "Hi, I'm the wicked stepmother,
Right.
and I've done all of these things wrong."
Right.
Right? She says, "Listen, I was married. My husband just passed away. He left everything to me." She gives me her version of events, and then when indeed she turns out to be the wicked stepmother, you discover that through the course of the litigation, when the other side puts on their evidence and depositions, discovery, or what have you, and it kind of illuminates you. And my job then, I see it as twofold. Number one, at the end of the day, when I take a case, I signed up to be the gladiator. To, if at the end of the day it requires it, walk into the courtroom and do my level best to get you the best result that can be obtained. Okay. That said, I also have another role. I'm a counselor. And
I have a speech in a can here too for my clients about counselors, but I want to hear yours first. Go.
Well, my job is to inform my client of the things that I am seeing that pose obstacles or problems for her, and inform her of the relative risks of proceeding or trying to pursue some kind of reasoned settlement, and to position her, if she wishes to settle, in the best position so that she can effectuate the most favorable settlement.
I see.
There you go.
Yeah. I tell people that I point at my license, and I feel bad, because I probably do this a lot. And if any of my clients are watching out there, you're not supposed to be on the internet. The judge took that away from you. So but I point to my law license, and I said, it says attorney and counselor, and I don't know why, because I didn't go to counseling school. I went to law school. And I do kind of joke with them that judges call us counselor when they're mad at us, but there is absolutely a counseling component to this, right? And it may be of various states, because again, you kind of one of the recurring themes that we've talked about today has been just people are people, even though they may be involved in a commercial litigation dispute, even though you may be representing a company who developed a product who somebody else is coming back and saying is unsafe. At the end, ultimately, there is a counseling role. Ultimately, even in those situations where you represent evil stepmother, or you represent a big corporation, or you represent somebody who is hurt or injured on the other side of it, there is a component of it that is that is trying to get the client to understand the bigger sense of things. And again, yes, losing money is one thing, not sleeping at night is another thing. Counseling and reconciling with that client what's more important to them, because ultimately they're the ones that can answer that. But the most important thing about all this is that you and I get paid.
Well, I will not lie. I enjoy being compensated for my work. I work hard, right? I do like what I do, but it can be very taxing. And you go to trial very often. I don't go to trial nearly as often, but I do go to trial. When there's a trial that happens, the world ceases to exist. I have only one thing in my life, and that is putting on the best trial that I can. Absolutely. Right. Whether I don't get to sleep, I don't eat, whatever the case may be, I do it. So yeah, I do enjoy getting paid, and I make a good living, but I also am willing to put it sounds kind of goofy, but I am willing to put my interests on the back seat sometimes to help something that should happen for my clients happen.
Well, ultimately, too, we want happy customers, happy clients, and that necessarily means that our interests always come second to theirs. If we don't get what we need to continue representation, that's on us. And speaking of trial practice and trial advocacy, back during the pandemic, I would have gone back to my office and slept for an hour or two. I've got a judge who's about to yell at me in 28 minutes. So we've got to wrap this episode of the Lawyer Show up. Thank you to my guest, Jorge Barunda, the Equalizer in Houston, by God, Texas. I wasn't able to take too many underhanded slaps at you guys today, but anyway, I'm going to go lose to you in Words with Friends, and we will see you guys next week or maybe the week after. Thank you, everybody.
All right. It was a pleasure. Thank you for having me on, Jeremy, and wait for your next move.
All right.